Now, when you end up in family court, this was my first appearance in family court. The judge issued. We went into court that the court ordered that the petitioner respondent submit to home studies and psychological evaluation to be scheduled through the probation department of Saratoga County. And then it gave me some visitation rights. It was ignored. But this is the big thing that people don't realize, and it's another denial of due process by our illustrious court system. It states here, ordered, adjudged, and decreed that the family court shall appoint a law guardian for the children of the respondent and the petitioner. These law guardians do absolutely nothing. The thing with the home studies, though, is this is what the order states with the home studies. It says here, having stated that an investigation should be made by the probation department of Saratoga County to cover the above entitled case and any and all material and relevant facts and reports of any type and nature. Ordered that the probation department of Saratoga County, under the supervision of the probation supervisor, make an updated investigation to cover the above entitled case and any and all material and relevant facts and reports of any type and nature, and that when completed the same reports are to be given to the judge of the family court to be used in the disposition of this matter. So part of his decision is going to be based on these reports by the probation department. That said court may permit the attorneys, if any, to examine the same. So the attorneys get to read the report, but you don't. I'll tell you, these attorneys, they read it, and especially with fathers, they see something that doesn't look good. Oh, it's all of a sudden the father's case is gone. They don't care if it's true or whatever. Now here's the kicker. Ordered that the probation officer who makes and submits the report in the above entitled matter will not be called upon to testify in the form of direct examination or cross-examination at the hearing date, and until further order of the court. They don't have to testify. That's a denial of your due process right to face your accuser. These people lie. Now, I'm going to get into that a little bit. After this one in '85, there were several others. Judge James, we had a hearing. Several days. All the transcripts are on my website from this. The court notes I couldn't have won the case the way he ruled it, no matter what I presented. All the witnesses were credible. Basically, it was proven, everything I stated was proven and more. He states, the court notes that in paragraph 5 of the petition, filed February 14th, '85, the petitioner, me, himself alleges, and then he quotes, throughout respondent's custody with the issue of the marriage, she has shown extreme financial irresponsibility as well as a lack of proper material supervision. Presumptively, whatever conditions existed on February 14th, '85, as perceived by the petitioner, existed in 1980, 5 years before, when the parties separated. Now, so basically he threw out everything, even though, but as stated before, it's supposed to be, their determination is supposed to be based on the best interests of the children. He doesn't want to address the best interests of the children. It says, it is the decision of the court, after giving careful consideration to all the proof offered by the petitioner, and after all doubtful issues have been resolved in favor of the petitioner. So everything's in my favor. That he has failed the burden of proof and motion to respond to dismiss insofar because he's claiming whatever happened in 85 also was happening in 1980. My youngest son was born in 1980. Now, this is what was stated. Now, notice he said paragraph 5. Paragraph 5 here starts, and it's on the next page, that since the entry of said judgment, there has been a change in circumstance in that during October, November, and December 1984 and January 85, and for a majority of many months prior, so months, not years, prior, respondent was not at home with the children at the residence supplied to her by the petitioner, but instead resided with her boyfriend, Carrie, at his residence. The children were watched by a live-in babysitter who, upon information and belief, is 23 years old. Now, this gets to where he said, I then stated that since 111 to 11385, petitioner has not been allowed to see his children, and that since the execution of the separation agreement, petitioner has been denied visitation on numerous occasions. That in May of 84, we bought a house. I tend to live there with the children if I'm granted custody of them. This is where he took it out of context. That throughout the respondent's custody with the issue of the marriage, she has shown extreme financial irresponsibility as well as lack of proper maternal supervision, as described above. These dates are all after that. He conveniently left out as described above, which would have been this and this, after the divorce, not before the divorce, as he's claiming in his order. This is how the judges fix the cases. They take stuff, they take a sentence and they cut it short. Now, as documented on my website, our website and everything else, I have all the courts I've been through. They just ignored everything I had, including Judge James. They don't care about the children. All they care about is the children go to the mother, and father pays child support, and in most instances, ordered to pay more than is required by statute. Now, as I was before, this time, before Judge Kramer, my youngest son, this was in November of 95, had a PINS petition filed against him for not going to school, and he was failing all his subjects. Now, so the school, thank goodness, filed a PINS petition against him. I got notified because I'm the father. Again, the judge ordered a psychological evaluation, and he also ordered probation to be involved. This is what the psychologist had to say, and this was done on January 25th, 1996. The parent-teen meeting began rather mildly and ended rather heatedly. It became clear as the session progressed that Everett and Mrs. Corella have extremely tense and angry feelings between them. My impression is that Everett has been in the midst of enormous conflict for years, including the string of petitions in family court. Arlene stated rather strongly that she wants respect. And I want this kid to go to school. Sounded increasingly angry when she described Everett does whatever he wants. I did not have the opportunity to complete a psychological assessment of Mrs. Corella, but the general impression was of a mother with a high frustration level. She described her house had become scum. She's got a free house, makes $30,000 a year, and she can't keep the house clean. It's scum. But she wasn't going to leave. The meeting ended with the argumentation, which was difficult to stop. though the appointment was over, Mrs. Corella stated that such discussions were not unusual in the home. You know, you've seen the testimony on her younger daughter. This is her youngest son. What happened was they issued a report. I wrote an 11-page, normally you can't see the report, as I stated a minute ago, but because I was representing myself in it, and the report, they did a report on me, I'm a party to the proceeding. I didn't have an attorney. As soon as you have an attorney, you don't see anything. Her attorney was allowed to see it. The law guardian who represented my son was allowed to see it, so why aren't I? So I filed with the court demanding that I be given a copy of the report. I got a copy of the report. 11 pages of one lie after the other. Miss Molly Dwyer lied in everything she stated, and I went through, quoted what she quoted, and stated why it was a lie or it was misleading. I sent it to her boss, Paul Viscucci, Director, Saratoga County Probation Department. This is the letter I get back from him. Dear Mr. Collins, this letter will acknowledge receipt of your letter to me dated December 3rd, 96. Oh, these are also on my website. The rules of confidentiality preclude me from commentary in this matter. The report is 90% about me and 10% about my son. And he can't discuss what the report says about me? He's there to protect Molly Dwyer. They don't care if these reports are accurate. This is what they do. This is why the judges don't want them testifying in court. Because they don't want them getting caught in lies after lie after lie. What confidentiality? The report was about me and Molly Dwyer making knowingly false statements of fact in her official report to the court. That is an official document that's filed with the court. She's a public servant. That's issuing a false certificate. That's a Class E felony. From experience, the probation department objective is to keep the child with the mother, no matter what. And that's what they were doing. Even though the psychological report, which she got a copy of that, states how bad it is in the household for my son and the mother. As I said, most fathers are not allowed to read the report. They are only given to the father's attorney, and most attorneys will not allow the father to read the report. The attorney will supposedly tell the father what is in the report. The only thing I got out of my first attorney, when James ordered it, was that my ex, uses the children as weapons against me when she was mad. I don't know what else was in the report. But that was a positive thing. Obviously, Judge James covered that up too. Because he did nothing about me not seeing my children. I didn't get make-up time like she did. I didn't get any. No father does. This is a deliberate denial of due process and equal protection of the law. Now, what happened afterwards? A year later, this was November of 85. This report was issued. When the PINS petition was filed, my letter went out December 3rd, dealing with all this. The next thing is, a year later, we're into 1997. What was done for my son? Absolutely nothing. They didn't care what happened to him. That's Judge Kramer, his law guardian, the probation. They don't care about the kids. What happened was, in probably April, he came to live with me. He couldn't take it anymore at his mother's house, so he came to live with me. The next thing happens a year later. My son came to live with me in roughly April of 97. This was in May of 97, roughly, the transcript. The court, Mr. Collins, pro se petitioner, the defendant represented by Mr. Eggleston. A do-nothing like all the law guardians. They're do-nothing. They just want to collect their $75 an hour. At that point, I think it was only $25 an hour. Ms. Johnson, probation. Your Honor, what is your position today with the petition? Your Honor, since our last court appearance, the respondent has re-enrolled in Shenendehowa High School with full attendance and is engaging in counseling. He is now spending the majority of time and reporting no problems in the home. Court, he is living with Dad? Yes. I'll tell you, you had to be in the courtroom. You can't see the inflection or what's going on in the courtroom. But I will tell you, Kramer wasn't happy. It was his voice. You could tell by listening to him. He was not a happy camper. But what else was he going to say? Ms. Shine, yes, I understand he spends the majority of time with his father, and this time I believe because of the complying with the conditions of the probation and with the court's permission, we are asking that the withdrawal of the violation of probation. I am glad to hear that, and I accept your withdrawal. Eggleston, Everett has done quite a bit to do that. Yeah, he did. He had no problems once he came to me. We didn't get any arguments. He just went to school. He did his homework. I never had a problem with him. But from November 1 or 15th, when they filed the petition against him, over a year and a half, they leave him in this position. He could have done a lot better if they'd given me custody when I filed for it. I did it because he wasn't going to school. We're not giving Dad custody. We want the child with the mother. He didn't do well until he came to live with me. This is what happens to children in the court system. Oh, just so you know, I have provided a petition on my website to get these reports from the court. If the probation department or anybody's writing a report that they're sending to the court, that also with a lot of times with psychologists, and they tell you pay for it, but you can't get a copy of the report because it is the court that has ordered the psychological, and they send them to the judge. You can't get a copy. Your attorney can read it over, but a lot of times they won't let them take notes or anything else, so they can take notes, but they can't have a copy of it. That's a denial of due process and equal protection of the law, because these people lie. The psychologists out there. There are a couple of good ones out there in this area. Most of them are horrible. Their only objective is to keep the mother with the children with the mother. And they'll sit there and no matter what little thing it is, they'll hammer the father. The mother, they just gloss over it. So, demand copies of these reports. You're entitled to them under the law. Go for it. As I said, I have one on my website that you can download and use. All you got to do is fill in the blanks, your name, the court, and stuff like that. But it's all there for you to get a copy of that report. And if you don't get a copy of it, make a motion. It's a petition for it. It's a motion. Appeal it. Who knows what the appellate court's going to do. But it's a denial of due process and equal protection of the law. And you need to make sure you get this so you can counter it. And there's no reason why that you should not be able to call these people as witnesses and not have to pay for them to show up, especially if they lie in the reports. In other words, they've given them basically immunity, the courts, not having to verify or substantiate what they state in their reports. They just throw stuff out there because they know they don't have to testify. They're not going to be questioned on it. If their judge is going to use a report against you, you want a copy of it. And you want to be able to question the person who wrote it. Two final things. One, I filed federal or felony complaints against Mr. Viscucci and also Molly Dwyer. Both, I think, felony and misdemeanor complaints with the Saratoga DA. You know what was done with them? Nothing. So in other words, the DA's office in Saratoga County puts the employees of the Saratoga County above the law. Now, one other thing about my son. After he came to live with me, his grades went up. He was getting A's and B's and a couple C's before he was flunking everything. He was going to school. He graduated. He started Hudson Valley in September. Unfortunately, in one respect, he quit. But he decided to go into the Marines. He spent 4 years in the Marines. When he walked out of the Marines, he was a sergeant. There aren't many people that go in the Marines and in 4 years make sergeant. They may make lance corporal, a few less will make corporal, but it's rare to make sergeant. He made sergeant. He got out and he got his 4-year degree from SUNY. So it's not like, you know, they want you to think the kids, well, he's not doing well in school, he's stupid or whatever. My son was not stupid. It was the home environment that was his problem. And the court wanted to keep him in that home environment, even after the Pins petition for over a year, before he came to live with me. That's the problem. The court, these probation people, the law guardians do nothings. They did absolutely nothing for my son except keep him in an environment that was not healthy for him. They should all be removed from the bench and fired for what they do, especially filing these false reports and everything. Molly Dwyer should have been fired. This system needs to be cleaned up, and it needs to be cleaned up now. All documentation concerning Justice for New York videos can be found at justicefornewyork.com. There are also family court petitions concerning the right to a jury trial, petitions to vacate support magistrate and judicial hearing officers' orders as they are issued in violation of the New York State Constitution, and there is also a demand for probation reports and psychological evaluations that the court orders, but the court orders that you can't read them or see them. That is a violation of your right to due process and equal protection of the law. They also order that the people preparing these reports do not have to testify and there is no accountability. This has to stop. Demand your reports so you can know what's being told to the court.